We turn now to our last panel for the day, looking at the legal aspects coming out of the Dirty Politics book. To do so, we have Professor Paul Roth from the University of Otago's Faculty of Law and Professor Ursula Cheer from the University of Canterbury School of Law. They will again talk for about 40 minutes, at the end of which there'll be an opportunity for questions. So for the final time today, send them in via Twitter using the tag @HagerDebate or #HagerDebate. Our first speaker will be Professor Paul Roth.
Hi. Well, I'd like to talk about information law issues raised by the Dirty Politics book, and I'd like to focus on the other side of the conversation, which is not the political skullduggery on the right, but what others like Muriel Newman, former ACT deputy leader, saw as or sees as the elephant in the room, or what I would call the elephant in the legal room, which is Nicky Hager's use of material that was obtained from a hacker who acted unlawfully. Muriel Newman this week has written a piece in her online newsletter called Stealing an Election. And this week's poll on her newsletter asks, would you like to see Nicky Hager held to account for the part he has played in the criminal activity surrounding the stolen emails? This is not a leading question, of course, but Muriel Newman asks, how can it be that Nicky Hager can receive stolen goods and make a profit out of them by publishing them in his book without being charged by the police for the crime of receiving stolen property? She opines that Nicky Hager clearly is liable to up to 7 years imprisonment because of the value of this stolen property. Now, as you know, we usually tell our students to avoid using the word clearly because this indicates that you might not be so sure. And so the short answer here is that in law, at least, emails are not considered generally to be property unless they contain something of intrinsic value, such as intellectual property, like a secret formula, a database, or copyrighted material. On their own, emails are just merely messages written in virtual reality, so they don't have any real existence as property for the purposes of the law. Where they do have some value or can provide the basis for some legal action is where the emails contain information. And so instead of using a property analysis, you have to use an information analysis when you're looking at possible legal liability that arises from the sending of email. And so if the issue is the misuse of information contained in emails, you really have to look at the common law and equity. For example, the law of contract, the law of copyright could be relevant in misuse of email information in some circumstances, but not here. There's no contract involved here, and there's no copyright issue arising. What we're dealing with mainly, as I understand, is simply email conversations and Facebook chats. So there's no copyright in that unless the conversation forms the basis of a script for, say, a movie or a TV show, or maybe a dialogue in a novel. All of these are possibilities that I could foresee for this issue in the near future. But two legal issues that are quite plausible in this situation are misuse of confidential information and breach of privacy. So these are legal actions that do have legs. Not receiving stolen property, forget about that one. So the first cause of action here is breach of confidence. And to make out an action for breach of confidence, the information has to have the necessary quality of confidence about it. It has to be communicated in circumstances that have a confidential vibe, if you will. And there has to be an unauthorized use of that information to the detriment of the party who communicated that information, whose confidence was violated. And I think it would be pretty straightforward to prove all of those elements in the present situation. So we come now to defenses, and there's a public interest defense where the information that has been communicated deals with a matter of legitimate public interest, as opposed to matters that simply the public might be interested in as a matter of scandal or titillation. So is this material in the book a matter of genuine public interest? Sometimes it's called, or aspects of this defense are called the iniquity rule. That is, there has to be some exposure of wrongdoing, something illegal, immoral, or just plain wrong. Another aspect of this public interest defense is where the individual whose confidence has been breached, have they courted publicity? So we're dealing with situations where the information disclosed is really a corrective to the projected image or a false image that has been presented, and the disclosure of confidential information is merely correcting information that's already out there. Probably one of the most famous cases in this area involved a case between Tom Jones and Engelbert Humperdinck versus their former press agent who wrote an expose book. And the English Court of Appeals said, well, that's fine for him to disclose all this information that he had received in confidence, because these pop stars had presented an image of themselves that was completely at odds to the reality, and the public had a right to know. So there are other cases along the same lines. So the public interest defense may well apply, but like so many other things in law, and that's why lawyers usually have jobs, nothing is black and white. It has to be slugged out. It's not an unambiguous answer here. The court's decision on these sort of cases the court's decisions are discretionary, but the discretion always has to be exercised in a principled way, which is to say they look at past cases to justify their approach. There are a number of factors that the courts will look at, such as the nature or weight of the public interest concerned. So there's an issue of proportionality between the public interest on the one hand versus the breach of confidence on the other. And frankly, publishing someone's emails and Facebook chats, it's a pretty big violation of people's privacy and their expectations of confidentiality of the conversation between the two parties. So there is a significant breach here, but the court would just have to look at whether the public interest in that breach was worthwhile, whether that could be justified. The court also looks at the nature of the breach. Was it seriously invasive? Were the details disclosed unnecessarily detailed? And I note from the book that in the introduction, Nicky Hager, expressly says, I'm avoiding any personal details, although there were a lot of them, and just sticking to the main issues. So there was a lot of probably personal information that was deliberately not included because it wasn't really relevant to the themes of the book. Another issue that the court looks at is to whom the information was disclosed. Sometimes the court says, well, the information shouldn't have been disclosed to the public at large. It was really none of their business. There's nothing they could have done about it. It should have been disclosed to the police or regulator. In the present case, arguably, the public at large probably was the appropriate group to disclose this information to. Court also looks at the motives of the disclosure. Was it merely to make money, to sell newspapers, to make a news splash, or were there serious public service motives underlying this? And then finally, there are many other factors that the court looks at. These are just some of the main ones. Finally, breach of or misuse of confidential information involves the law of equity. It's an equitable remedy. And so the court actually sort of stands back and says, well, is it fair that we grant some sort of remedy? There are a number of maxims of equity, including he who seeks equity must do equity. If you're seeking equity, you must come with clean hands. I'm not going to say anything about Cameron Slater here, but you can make your own judgment measuring his conduct against that of these maxims. So breach of confidence is a definite runner here. I wouldn't say, it definitely would fall this way or that way. Ultimately, it's the discretion of the court. So all I can say is these are the factors that a court would consider. I would say Nicky Hager has a pretty good chance, but who knows? On the right day, maybe Cameron Slater might have a good chance as well. But that's basically the legal framework in which that would be determined. Secondly, there's a privacy tort that applies where publicity is given to private facts about someone where there's a reasonable expectation of privacy, and that publicity would be highly offensive to a reasonable person. By offensive here, I would think, if there were salacious details, if there was a real invasion of privacy. Again, it's up to a judge to decide whether the information in the book that's been disclosed would be highly offensive to a reasonable person. I know a number of people are offended by the way in which the information was obtained, but that's not the same thing. As with breach of confidence, there's a defense of legitimate public concern in the information. So that takes care pretty much of equitable and common law remedies. Thirdly, we come to the Privacy Act. And so the first issue under the Privacy Act would be whether Nicky Hager is a news agency engaged in news activities, because if he is, then the Privacy Act doesn't apply to him. There was a recent case in June involving, it was .com and the Attorney General, and the judge in that case took the view that a journalist who wrote a biography about Kim.com was an agency that was liable under the Privacy Act, because the Privacy Act was limited to articles and, the Privacy Act exemption was limited to articles and programs and didn't extend to books, even if books deal with current events and current newsworthy people, as everyone would agree .com is, and as everyone would agree, Judith Collins and Cameron Slater are. In that recent court case, the court's interpretation of the Privacy Act was not definitive because the issue didn't come before the High Court in a proper way. That is, it wasn't a determination under a Privacy Act proceeding. It was, by the way, in another type of proceeding. So what we're dealing with here is not, strictly speaking, a legal precedent. It might be persuasive to another court, but in and of itself, it's not legally binding as an interpretation of the Privacy Act. And also, the interpretation or the approach of the courts in New Zealand towards what is a news activity is quite wide in New Zealand. In fact, I think it's ridiculously wide. It covers, and the the significance here is that if you're a news medium engaging in a news activity, you're not covered by the Privacy Act. You're immune from it. So what's covered, for example, under the news activity exemption has been the Target program on TV, which is, reports about consumer ripoffs and tradespeople sniffing people's underwear while they're not at home. That's a news activity. The National Business Review Rich List, that's a news activity. And so is a letter to the editor of the New Zealand Beekeeper magazine. So if all of these are news activities, I can't see why a book on current events like Nicky Hager's book shouldn't be a news activity as well. So there's clearly some legal ground to stake out here if the issue ever came to be determined. Ironically, Cameron Slater is currently locked in a Privacy Act case himself in relation to his stories about the businessman Matt Blomfield. And that information was sourced from Mr. Blomfield's hard drive, and he's trying to use the news activity exemption himself as a blogger. So if Nicky Hager is not a news medium carrying out a news activity under the Privacy Act, then we proceed to Principle 11. He's disclosed information, personal information, about other people, and there doesn't seem to be a relevant exemption under Principle 11. So what you go to next is the savings provision in the Privacy Act, which is Section 7. That subjects the Privacy Act to any other law that authorizes the disclosure of personal information. That brings us to the New Zealand Bill of Rights, which says that everyone's got the right to freedom of expression, subject to reasonable limits prescribed by law, as can be reasonably justified in a free and democratic society. And that in turn brings us back to breach of confidence, breach of privacy, and their public interest exemptions. So through all three of these avenues, we pretty much have the same legal approach that's applicable. If Nicky Hager is nailed under the Privacy Act, he can always, as a last-ditch effort, he can always rely on Section 85 for some sort of mitigation in remedies awarded against him, because Section 85(4) says that the tribunal shall take the conduct of the defendant into account in deciding what, if any, remedy to grant. So you would ask, is Nicky Hager, did he act maliciously? Was he earnest in his beliefs about the publication for the public good? It was, a positive thing, at least, that he left out personal life details. So all of these elements, even if he was nailed under the Privacy Act, would act by way of mitigation. So that's basically an outline of the sort of legal issues that we would be dealing with. Standing back from the whole affairs, I think it's got to be asked, would this information have got out otherwise than through publication of this book, even though it involves the publication of Facebook chats and email conversations? So if the answer to that is no, this information would not have come out otherwise, then you'd have to ask, or a court would have to ask, is this information the New Zealand public should know about? And I think, this is what it all boils down to in the end. And now I'll pass off to Ursula.
Thank you. Thanks, Paul. Thanks, Andrew. When Andrew asked me to take part in this panel from a media law point of view, I was thinking about, what does this book give rise to? What are the issues that are important and I need to talk about? And apart from privacy and confidentiality, which were fairly obvious ones, I thought, what about looking ahead to the future, and what sort of maybe changes to the law might be signalled or should need to be discussed from all this? And so I want to talk about two things today, and the first is the possibility of regulation, and Bryce raised the issue of worrying about blogs being regulated or crushed or controlled or licensed, and I can certainly talk about that shortly. I think, first of all, I can say right away that's not going to happen. It's highly, highly unlikely. So I want to talk about this report here, this big thick tome on my knee, which is a report that was issued by the Law Commission 2 years ago, and it looked into this very issue of how should the media be regulated in a new way of some kind that draws in new media as well as mainstream media. So the Law Commission spent a long time looking at this and very comprehensively reported on it. And I want to talk about in particular the definition they came up with as to how we would define journalists and news media in a way that would allow us to recognise when they should have the privileges that go with that. And the second thing I'll just mention in finishing is the harmful digital communications bill, which is currently in Parliament. It's come back after it's been through Select Committee. It hasn't had its second reading yet, and I want to talk about the possible impact of that if and when it's eventually passed. So turning first to this report, the News Media Meets New Media, I can't do any better really than to read from it, and I hope you'll forgive me. I'm not going to read screeds, I'm just going to read a little bit. But the Law Commission, as is their wont, look very closely at the history of media. They go right back to the beginning and look very comprehensively as to how we got to where we are now. And what they talk about generally in relation to that is mass circulation newspapers and broadcast media equivalents led to this new political force, public opinion, which I think has been mentioned by our other panellists today. And this was to have a profound effect on how governments behaved and how democratic institutions evolved over the 170 years or so since the early 19th century. So then the Law Commission identifies that throughout the 19th and the 20th centuries, this idea developed that the press has had an important role to play in the democratic process that took hold, and this became a central plank in the defence of an independent and a free press. And this led to an individual's fundamental right to freedom of expression becoming conflated with the idea of freedom of the press. You often see those two ideas pushed together or dealt with in the same breath. So we're talking about a commercial press here, but nonetheless, this whole background led to the idea or an expectation that even this commercial press is going to be accountable in some way to the public, and that they've got this quasi-constitutional function that they're carrying out, and that's with us now, and the laws and any ideas of regulation are based on this idea. So the Law Commission goes on to say, they talk about the special position of the press leading to special freedoms that they had, freedoms and privileges. And in New Zealand, there are things like the right to be in court and report on our behalf, being the eyes and ears of the public, and the right to be there even when everyone else has been shooed out. The exemption under the Privacy Act that Paul's just been talking about. And there are many more of these. The right now in the, or privilege as we should call it, in the Evidence Act for journalists not to disclose their sources unless it's absolutely necessary in the interests of justice. So these are privileges that have been given to the press, journalists, the news media, and developed over time in order to perform that very important public function for us. So the point where we get to now is that these freedoms that the press have are matched by responsibilities. And foremost amongst these, and these are mostly built into the codes that journalists have, and I think someone earlier today in one of the panels talked about this being part of a journalist's professional image. Now, to me, it's more than that. It's part of the law because it's in codes and it's in our forms of regulation as well. So it's not just about how we think of journalists and how they should be. It goes much deeper than that in a regulatory sense. So we're talking here about the public being able to rely on truthfulness, accuracy, fact and opinion being clearly differentiated. You're not stopped from exercising the right to have an opinion. If you're still news media, we've got plenty of political columnists, there's plenty of opinion in the news. It's not just out there in blogging land. So those rights are very important, but there has to be transparency around that it is clearly delineated so the public know what's actually happening. The public needing to be confident that the news media is not going to use its considerable power and influence to deliberately mislead or to cause unjustifiable harms. And I really like the way the Law Commission's described that next. They say, in crude terms, this describes the social contract that's understood to exist between mainstream news media and the public that it's serving, and on whom it's as well relied for commercial success, obviously. Now, what the Law Commission used this discussion for then was to try and develop a definition of the news media which would take in new media. And their idea was that we've got a number of statutes, the Privacy Act being one, the Evidence Act being another, where there are definitions of news media, and that entitles them to those special freedoms that I've been talking about. And the Law Commission was trying to draw this all together, as they're quite good at doing that. They tidy the law and make it accessible, and their reports generally are aimed at making the law work better for everybody and being more accessible and more easy to understand. So their idea was we should have one definition in all our statutes in New Zealand, wherever we're talking about media. And the first decision they had to make was, well, should this include new media? And they decided, after looking at the matter for 2 years, seeking input, they consulted, they received submissions from the public, and for a Law Commission report, they got quite a good number of submissions on this. David Farrar submitted, other bloggers submitted. They interviewed Cameron Slater. So they looked at the new media landscape and tried to take account of that and consult properly and hear what everybody had to say. And of course the media made submissions and so on as well. And so at the end of the day, they came up with a definition that they thought would do the job. And I'll tell you what was in that. I'll read this because I want to be accurate about it, if you'll excuse me. So, a statutory definition of news media. They said, the statutory exemptions and privileges we've been talking about would be met if any entity or individual meets the following criteria. So they've got a set of 4 criteria here. A significant element of their publishing activities involves the generation or aggregation of news, information or opinion of current value. Secondly, they disseminate this information to a public audience. Thirdly, the publication's regular and not occasional. And fourthly, the publisher is accountable to a code of ethics and a complaints process. So they've got a kind of description of, what news media would look like, and then they've got a kind of an added requirement or condition of being accountable to a code of ethics and a complaints process. And the idea was to encourage regulation in this way, to invite new media into the stable. And as long as they met this definition and also were accountable to a code of ethics and a complaints process, then in return they would be entitled to be recognised as news media generally. But they weren't mandating that in a statute, but the point was that any statutes that gave media privileges and those special freedoms we've been talking about would allow new media to have those as well. And looking back at this definition now, of course this was all before the publication of Dirty Politics and the information that's in there about the behaviour of certain blogs. I think this definition has got something missing, and I think more thinking needs to be put into this idea of what is news media and what is a journalist. And I think there's more to it. There must be more to it than just churning out news, just getting news from somewhere and churning it out. It's all well and good that you might be accountable to a code of ethics and a complaints process, but if your stories are being fed to you and you are publishing them for your own reasons that may or may not be malicious, may or may not be political, and or you are being paid to place those stories and you have an outlet to do that, then you're and to my mind, not news media. You are either a public relations consultant, you're a communications consultant, or you're a blogger who has a very bias one way or another way. You may even be a toxic blogger. You may be extremely malicious, and you may be attacking people and being extremely harmful to them. So this definition, I think, was an attempt to invite new media in, but I don't think it took account of this extra element, which I think Nicky's book has raised and I think needs more thinking. And I would like this report, it actually recommended an overarching new regulator for all media, including new media, but it was going to be a voluntary type of regulator. So you didn't have to belong, you could still sit outside it if you wanted. And the government, in the same year that this report came out, declined to implement this report. So nothing's happened as a result of this report. There's been no decision to implement that definition, to change the definitions in the statutes or anything of that kind. And I think this could be revisited. I would like it to be revisited, not necessarily in relation to a new regulatory scheme. In fact, the press don't want that and are not sure about that. But in terms of getting a clearer definition around what news media is or what journalists are, I think that's a good idea. And it would be good, for example, if whichever government gets in after the election, perhaps sends this back to the Law Commission to have another look at, or someone in opposition could sponsor a private member's bill. There would be ways of getting this possibly into the House to be looked at again. And the reason I say that, and the reason that I think a definition of that kind needs looking at again is, and this was raised at the time that the report was prepared and submissions were taken, a number of media and others raised the issue about the dilution of media's legitimacy. And that's what I see Nicky's book as very much pointing up and raising the spectre of the loss of the news in the way, the loss of the news into forms of new media that are no longer either regulated or no longer but obey those rules of that social contract that I talked about at the start. So this is one possibility. It's not law yet, but there is a possibility that that could be looked at again. And the idea would be then that you have bloggers who want to be seen as media in that way, as long as they meet those requirements. It's a good thing, of course, if they set up codes of conduct and have ethical systems to deal with complaints, or if we don't get a new system of overarching regulation, of course they can apply to join the Press Council or the Broadcasting Standards Authority, or now the Online Media Standards Authority. Now, my understanding is that Cameron Slater has in fact applied to join both of those, and nothing's come of that as far as I know. And David Farrar, I understand now, has said that he will sign up to one of those bodies. So we see a move by one of those bloggers mentioned in Nicky's book to, there are other things that David Farrar has said now that he will do, such as becoming more transparent and declaring where his funding comes from and things like that. So you see there some moving into a more regulatory situation of at least one of the blogs mentioned in the book. What happens about blogs that are right out there and don't change and don't become transparent and don't become more ethical and upfront about what they're actually doing, and they're actually causing serious harm to people from publishing material? This is where I want to mention the Harmful Digital Communications Bill. This is a bit of a... we're not sure where this is going to go, this bill, just quite what its effect will be and quite how effective it will be. It was originally intended to deal with cyberbullying. And in fact, it was part of this report. The Law Commission was asked to look at cyberbullying specifically in the second part of this report. And what happened was Judith Collins lifted out the last part of the report and said, well, we're going to implement cyberbullying regulation, but we're not going to implement anything else about regulation of the press generally. of course, that was a highly attractive policy to follow and a highly attractive new sort of law reform to bring in, and that's why the bill has got as far as it has in terms of the parliamentary process at the moment. I would think no matter what happens at the election, either government, whoever the government was, will probably pass this. You'd agree with that, Paul?
Yeah.
And this, I like the approach in the bill in the sense that it is designed to be accessible and reasonably easy to use. It's based on a model a bit like the Privacy Commissioner's Office. It's based on a set of digital communications principles, and then you have a first step where someone who has suffered serious harm from something that's been published about them online, digitally, can complain to an agency. Now, we still don't know who this agency is going to be. It's been originally suggested that it would be NetSafe, or a body like NetSafe. As I say, we still don't know who that is going to be, and there's quite a lot of onus going to go on to that agency, whatever it is. And the idea is that agency will work between the parties involved to get information taken down as soon as possible, to mediate between them, to find some resolution between the parties that doesn't involve having to go to court or to pay, you know, for a court case, breach of confidence or whatever it might be. So from that point of view, the aim is more accessibility, and I think it's very attractive from that point of view. If you look at the communications principles, there's 10 of them, and they cover just about every form of published speech that could cause harm under the law in New Zealand at the moment, don't they, Paul? I would say. It covers digital communications that disclose sensitive personal facts, so that's privacy. Digital communications can't be threatening, intimidating or menacing. Those are crimes now. A digital communication can't be grossly offensive to a reasonable person in the position of the individual, whoever it is. They should not be indecent or obscene. They should not be used to harass individuals. They should not make false allegations. That's defamation. They should not contain matters that are published in breach of confidence. They should not incite or encourage anyone to send a message to anyone for the purpose of causing harm, so inciting someone to cause someone else harm. They shouldn't incite or encourage someone to commit suicide, which was one of the great concerns around cyberbullying. And they should not denigrate people because of their colour, race, ethnic, national origins, religion, gender, sexual orientation, all those things under the Human Rights Act. So a toxic blog could offend all of those, almost all of those principles, either altogether or individually, is my view. There has to be serious harm, and then you go to the agency, try and sort the matter out. If you're not happy with what happens there, it's moved into the district court, and it actually becomes a more formalised process, and there things become, as I say, a bit more formalised and probably a bit tougher on the individual involved to actually do that. So there's going to be this remedy, this form of this jurisdiction there that I think will help against toxic blogs generally. What these things require, of course, is courage. You still have to have courage to engage these rights that are in here. And I think the fact that this is a more accessible system, I think, helps that. Moving into a district court process is tougher, I think, on ordinary people. If it's about your privacy, it's tough. If you're scared to complain, then you won't use this process. And I don't know the answer to that. So at the moment, this is in the pipeline. It's not here now. And as I say, I'll be very interested to see what actually happens with this once this legislation is passed. Thank you.
Thank you. Paul, question to you first.
Okay.
You've intimated that there may be some legal recourse against Mr. Hager, but perhaps more on the unlikely side than the likely, or at least a 50-50 call.
Yeah. Some
people may look at that and think, well, that's just crazy. I mean, here is information that has been stolen. I don't think there's any doubt that this has been obtained through criminal methods. And here it's been able to be splashed all out in the world, even though it's come from criminal methods. So why? Why doesn't the law come down and just say, you can't use this at all?
Well, just because for quite some time there's been this public interest defense, and it'll all come down to the judgment of the court to decide whether the publication was justified in these circumstances or not. And I don't know the answer to that. Mm-hmm. All I can say is, these are the various factors, as I mentioned, that a court would take into account. Personally, I don't know, 50-50. It's not an open and shut case on either side. It would be a slugfest.
So do you think this then opens the door to this sort of behaviour in the future? Is Pandora's box open now? Is this all going to come out? Will future people on both sides be wanting to do this?
Well, I think it's been done already, hasn't it? Cameron Slater got hold of Mark Blumfield's hard drive and started apparently using that on his blog. So, yeah, Pandora's box has been open for some time.
Right. With regards to the Law Commission, the Law Commission took this approach that said we want to define what news organisations are. Essentially, if you are one, if you're a journalist, you get all these protections. If you ain't, you aren't.
Yeah.
Did that get it round the wrong way? Should we actually be looking at journalism to say that if a piece of work is journalism, it's protected, irrespective of who does it?
Yeah, that's my thinking. That's exactly, there was too much focus on whether news stories were churned out, and that was about it. But it's the question of, yeah, as you say, is this journalism? And then that can cover new media, as long as it is journalism. Now, one thing I just wanted to say, I noticed on the feed that someone's saying, well, if you're objecting to paid copy, then all newspapers are going to not be seen as news media and so on. The distinction between news media and news media outlets now, publishing and of course selling newspapers and so on, is that that's after the event. It's not that the way they got the news and the news that they got was paid for to start with, and that's the objection. That's what's being objected to. So the idea of journalism per se, of course, and the courts recognise this and the laws recognise this, of course media has to make money. It is a commercial entity, there's no doubt about that. But that's not what's happening in a sort of a blog that we've been talking about, a blog where there's a blog holding itself out to be news and news media, but is not behaving that way. In fact, it is taking paid copy. It is behaving like either an advertiser or a public relations consultancy.
Of course, Cameron Slater is in court today,
yes,
seeking an injunction.
Yeah.
Would you, either of you, like to talk us through what he's looking for, and then do you want to give a prediction as to what's going to happen?
Look,
Up to you.
My feeling about this is it's an interim injunction application, so this is an urgent application dealt with on the papers. The judge won't have that much evidence in front of him. They'll have whatever the parties can get together up to now. And Cameron Slater is saying, I want this now and I want you to decide this now on the papers that you've got. And the judge, in my view, will follow the process that Paul's talked about. Is this confidential information? There's an issue around that because I think in two respects, because as Paul suggested, there can't be confidentiality in iniquity, the idea of information that discloses something unethical or wrong that's gone on, and there can't be confidentiality in information that's already public, as you said. So I think there's a question at that point, isn't there, that can be debated.
There's also the balance of convenience, which might favour Cameron Slater. There wouldn't be any detriment to the news agencies if they delayed publication for a few weeks.
Well, and,
few months.
And the other issue that I thought works against the media is that often they won't deal with public interest at this point, will they?
No.
They prefer to leave it till the final trial, and they will say we can't deal with it in an interim process. There's not enough information in front of us. So I think this is why Paul. Well, you speak for yourself, but I personally think there's a strong argument of a public interest defence, but I think the circumstances of this application may prevent that from being used effectively at this point.
One last question. To what extent can the law solve things here? Or are these issues that the law may have some impact on, but what we're really talking about are wider cultural issues, issues to do with what the media is prepared to use as a reputable source, etc.? Thoughts?
Yeah, well, it's just unfortunate that things have reached this state that people don't act properly, I suppose, or they mask their real motives, and maybe it's in the interests of society to know where people are coming from when they write their blogs or whatever. But on the other hand, it is a sorry state of affairs where you have to invade someone's privacy to expose that. So it's a lose-lose situation, pretty much.
Yeah, the law can't solve everything. And we've got a tendency in New Zealand to think, oh, you know, let's pass a law, let's sort that out. And that's why, you know, going through these two possibilities here, anything you achieve from that is limited, and it depends on people having courage and time and all of that to use the processes that are there. Getting a definition right of news media, if you can actually develop one, and that's not an easy process. So the answer is it's a mixture of everything. The law can do some things, and then the sorts of things the other panels have been talking about, those grassroots things, those vigilance things, the law can't resource the media better, and it can't, you know, give them more time to go out and keep blogs like Slater's blog honest and so on. That's never going to happen. But we shouldn't make blogs be licensed because of that. You know, it was our newspapers who were licensed back in the 80s was the last time we got rid of licensing, and that will never occur again, especially now that we've got the Bill of Rights with freedom of expression in it. So it's a mixture.
Yeah, and just a final comment about the Harmful Digital Communications Bill. I think it was originally aimed towards school children, because there were surveys done that it was school kids that are mainly the ones to send and receive these harmful messages. And in our usual New Zealand over-regulatory way, we've got a bill here that will maybe bring things back to the playground, so people won't send these messages, they'll just bully in person.
And on that hopeful note, we've now come to the end of our third and final panel discussion. So thank you to our panel members, Professor Paul Roth from the University of Otago's Law Faculty, Professor Ursula Chair from the University of Canterbury School of Law. We'll now take a very short break before we come back for our final segment with the author, Mr. Nicky Hager, to discuss what he thinks of today's proceedings. Thank you.